Well, reactions have begun to trail the appeal court's ruling in Kano State. Earlier on, I spoke with legal practitioner Ufeli to get his thoughts on the judgment of the Court of Appeal in Kano on what is supposed to be a pre-election matter.
A large chunk of the votes that was ascribed to him were nullified because those votes didn't have the signature of INEC therein. So the issues of qualification and disqualification ran against him, which is both a pre-election and post-election matter, and also the issue of a huge chunk of the votes that were ascribed to him were taken down. And when that happened, if you look at what is left and compare it with the adverse party, that's the APC candidate, you'll now find out that by count, the APC candidate appears to have won that election. But you know, at this level, the truth is that he will still remain the governor because there are options of appeal left. I mean, there's still an option of appeal left, which is the Supreme Court. From the tribunal first made that findings, and same was upheld by the Court of Appeal just today. He will still remain the governor because they will bring a motion to stay execution of that judgment, and they will appeal to the Supreme Court, and the Supreme Court will be the final say on this. If the Supreme Court upholds it, fine. If the Supreme Court upturns it, then so be it. But the option of appeal must be open for him to exercise. That is talking about the governor now.
We're beginning to see that the court take pre-election matters serious, just like the case in Plateau State. Is the dynamics of election litigation changing?
I won't say the dynamics is changing, but I will say by virtue of the new Electoral Act, okay? Because if you look at what turned out in Zamfara, by virtue of the new Electoral Act, where INEC had gone as far as making regulations, and I've said that by the Electoral Act, they are not bound by their own regulations, okay? Because if you look at what happened in Zamfara, the Court of Appeal ruled that using the IRF squarely to determine the victory at the polls was wrong, since the Supreme Court has already ruled that the IRF is not a determining factor in terms of what the outcome of victory should be. I would say that the judgment of the court with as regards this seems to be unappealing. Unappealing to me to the extent that if you say IRF should not be relied upon because it's just for the viewing public, in a way you are saying technically that the public, whatever is there, the public can view whatever they want to view. But that what is important is what INEC counts at the back end. So the Supreme Court first laid that issue up there, and then the courts beneath are being, influenced, as it were, under legislation or under our legal system. They are supposed to follow the lead of the Supreme Court as a superior court. Okay, so the Electoral Act brought innovation, and I cashed on it to enhance integrity of the polls by saying public viewing of the IRF. But then, because the Electoral Act says don't make it compulsory, and then the Supreme Court will have to give that judgment that is not compulsory. Therefore, if INEC then goes to rely on it, and INEC also contradicts itself. So why go to rely on it when you have said it is not the determining factor is not the yardstick? That's talking about Zamfara. So the dynamics are changing. You are right. But I also think that the judgment is not entirely helping the cause of justice in the election petition.